The email arrived on a Thursday at 6:14 in the morning. I know the time because I had not slept. I had been sitting at my kitchen table going through the project files again, looking for the flaw they said was there. The flaw that justified refusing to pay $63,000 for work that was already live on their website. The email had 4 sentences. The last one read, "If you pursue this further, we will make sure the industry knows exactly what kind of agency you run." I read it twice. Then, I set it down next to my coffee, opened a folder I had started 3 months earlier, and added the email to the stack. There was a clause in our signed contract, Clause 14, that I had written myself 18 months before I ever met this client. At the time, I thought it was overly cautious. A formality. Something a paralegal friend had suggested, and I had added mostly out of habit. It turned out to be the only thing that mattered. But to understand why that clause was the one thing they never read, you need to know exactly who the marketing director was and why I almost let him win. By the end of this story, you will understand something most small business owners learn only after they have already lost. The moment a client threatens your reputation instead of disputing your work, they have already told you everything you need to know about the strength of their actual position. The threat is the confession. And if you had the right language in your contract before they ever signed it, you already have everything you need to respond. There is one paragraph in a signed agreement that ended this: not a phone call, not a confrontation, not a meeting where anyone raised their voice. One paragraph I had written myself, that they had signed in blue ink, that I had scanned and stored in 2 separate locations the day the contract was executed. This is how that paragraph worked. My agency did brand identity and digital marketing work for mid-sized companies' websites, campaign assets, brand guidelines, social media systems. I had built it over 6 years from a single laptop in a spare bedroom. 2 full-time employees, 4 contractors I trusted, a steady roster of repeat clients who came back because the work was consistent and the communication was clear. I was thorough. Not because I was born that way, but because the first serious client dispute I ever faced had cost me $9,000 and 3 months of sleep before it was done. When that ended, I went back through everything, every process, every communication habit, and rebuilt it from the ground up. Contracts, scopes, written sign-offs at every project phase, a documentation trail that tracked every revision request, every approval, every client decision from kickoff to delivery. 2 things my team knew about me, and that I held myself to without exception: I kept my word even when it was expensive, and I returned every client email within 24 hours, regardless of what else was happening. The client came through a referral from a vendor I had worked alongside for years. The marketing director, I will call him Gareth, had a reputation for being demanding, but fair. That was the exact phrase the vendor used. Demanding but fair. I filed it in my head and moved on. Gareth showed up to the first meeting with a prepared brief, a signed ENDA, and a clear budget. He asked intelligent questions. He challenged 2 of my initial creative concepts in ways that actually improved them. He pushed back on one deliverable timeline and offered a reasonable reason for the adjustment. By the end of that first meeting, I had decided this was the kind of client I wanted more of. We signed a contract in November. The scope covered a full brand identity system, a 12-page website, a campaign asset library, and a quarterly content calendar. Total contract value, $63,000. Payment structured across 3 milestones: $22,000 at signing, $22,000 at midpoint phase approval, $19,000 at final delivery and sign off. He paid the first 2 milestones on time, both by wire transfer, both with written confirmation emails from his office that specifically referenced the milestone names from our contract. By early March, all deliverables were complete. The website was live. The campaign assets had already been deployed across 3 platforms. The brand guidelines had been distributed to his internal marketing team and his print vendor. 2 weeks after launch, Gareth sent a note saying the work had landed well internally, and he was already thinking about the scope of Phase 2. In April, the final invoice sat unpaid for 30 days. I sent a follow-up on day 31. Standard language. Invoice reference number. Due date. Balance of $19,000. He did not respond. I sent a second follow-up on day 45 with a read receipt enabled. He opened the email within an hour of delivery. He did not respond. On day 52, I called him. He answered, which surprised me. Then, he said something that surprised me more. He told me the work had not met expectations, that there were fundamental issues with the deliverables, that his team had been forced to make significant corrections before anything could be used in market. I was sitting at my desk with the project folder open in front of me. I had 47 documented sign-offs across the full project lifecycle. Phase approvals. Revision confirmations. A final acceptance email, dated and signed 3 weeks before the website went live, from Gareth's own account. I asked him to send me a written summary of the issues he was describing. He said he would. He never did. 3 weeks after that phone call, I received a formal letter from a business attorney Gareth had retained. The letter stated that the deliverables had contained material deficiencies, that the client had suffered financial harm as a result, and that the client was withholding final payment pending resolution. The letter did not describe a single specific deficiency. I read it 3 times. Then, I opened the project folder and started building a timeline. The first thing I found, every deliverable had been approved in writing, phase by phase, revision by revision, final by final. 47 documented approvals. The letter claimed deficiencies in work that his own team had signed off on, in writing, with dates attached to every confirmation. The second thing I found, those deliverables had been live publicly deployed, in active commercial use for 6 weeks before I ever received the letter. His company was running paid advertising campaigns using campaign assets I had designed. The website was indexed and receiving traffic. His social media accounts were posting content directly from the content calendar I had created, and he had approved. He was using everything. He was refusing to pay for any of it. But the third thing I found was the one that stopped me cold. I went back through the full email thread from the beginning, not just the recent months, but the entire correspondence from the first discovery call through the final delivery confirmation. And buried in week 3 of the project, inside a thread that had been about a minor revision to the logo lockup, Gareth had written a single sentence that had nothing to do with the revision. He had written, "Between us, I have a review mechanism I use when vendors overcharge. Just so you know, this isn't personal. I had not registered it at the time. It had felt like posturing. I had responded about the logo revision and moved on. Now I was reading it again at 11 o'clock at night at my kitchen table, and I understood exactly what it meant. This was not a dispute about deficiencies. This was a mechanism. This was the system. I searched his name alongside the word invoice and payment dispute in 2 industry forums where vendors in my field occasionally posted about client issues. I found 2 posts. One from a copywriter named Diane, posted 18 months earlier. She had been owed $11,000. She had eventually settled for 60% after a months-long standoff, accepting the first offer because she had no documentation to support a stronger position. The second post was from a web developer named Marcus, posted 6 months after Diane. He had been owed $26,000. He had walked away entirely. In his post, he had written one sentence that I read 3 times before I moved on. He had written, "I didn't have the contract language to fight it. I wish I had." My business attorney reviewed the letter and told me to think carefully before proceeding. She was not being pessimistic. She was being responsible. She walked me through what litigation against a corporate client with retained legal counsel could look like: the timeline, the discovery process, the cost of depositions, the way opposing counsel could turn document production into a months-long exercise designed purely to exhaust a small business owner who had other things to manage. She said, "You might win, but winning and recovering are 2 different things." My accountant was more direct. He said, "Write off $19,000 and move on." The math does not support a fight at this scale. I talked to 2 agency owners I respected, both of whom had been running their businesses longer than I had. Both said the same thing in different words: let it go. Use the experience to tighten the contracts going forward. You cannot change how clients like this operate. One of them said, "You'll spend money proving a point to someone who will never care that you proved it." For 4 days, I sat with all of that. I sat with it on a Thursday afternoon in my car, parked outside a coffee shop because I did not want to go back into the studio and face my team while I was still deciding. I had 2 employees whose salaries I paid from the same operating account that the unpaid $19,000 was supposed to replenish. I had a quarterly tax payment due in 6 weeks. I had a lease renewal coming up on the studio space. $19,000 was the exact distance between a stressful quarter and a genuinely dangerous one. I drafted a settlement email, 60% of the balance, $11,400, case closed, done. I had the email open in a tab. I had my hand on the mouse. And then I did something nobody told me to do. I closed the draft. I opened the original signed contract. Not the letter from his attorney. Not my attorney's summary notes. The contract itself, from page 1. And I started reading. I read the entire contract. Not looking for anything specific, just reading it the way I had not read it since the week I had written it, because in the months since, it had become a background document instead of a living one. I made a list as I read, not a strategy, a list of what I actually had. Item 1. A signed contract with a payment schedule, payment amounts, and the exact delivery milestones each payment was tied to. His signature on the final page. His initials on the milestone schedule. Item 2. 47 written sign-offs across the project lifecycle, including a final acceptance, confirmation his words, his account, his date 3 weeks before the website went live. Item 3. 6 weeks of documented commercial deployment of my deliverables following that final acceptance. Screenshots I had taken on instinct during a routine site check the week after launch. Ad campaign archives. A cached version of the live site, timestamped and saved. Item 4. 2 prior milestone payments with written confirmations referencing the same contract name and the same milestone language as the unpaid final invoice, which meant he had already acknowledged the contract as valid and binding twice, in writing, by paying against it. Item 5. Clause 14. Clause 14 had 3 subsections. The first was a late payment penalty 1.5% per 30-day period on any unpaid balance after the net 30 due date. The penalty had been accruing for 41 days by the time I was reading the clause. The amount was not the significant part. The second subsection was an intellectual property ownership clause. It stated clearly and specifically that all creative rights and intellectual property in every deliverable remain the legal property of my agency until receipt of payment in full. The client received a license to use the work only upon final payment clearing, not upon delivery, not upon acceptance, upon payment. He had been running paid advertising campaigns using those assets for 6 weeks. He had a publicly indexed website built from my design work. His sales team was using printed collateral produced from my brand guidelines. All of it, every deployed asset was, under the precise terms of the contract he had signed, still legally mine. And one name I kept coming back to as I read the third subsection, my paralegal friend. The one who had pushed me 3 years earlier to add this specific language when I had thought it was excessive, was the person I called that same afternoon. The third subsection required any deficiency or quality claim to be submitted to the agency in writing, with specific itemization of each deficiency, within 14 calendar days of written delivery acceptance. Claims submitted outside that window, or without the required specificity, would not be recognized as grounds for withholding payment under any provision of the agreement. Gareth had sent written delivery acceptance 3 weeks before the website launched. He had deployed the work commercially for 6 weeks after that. His attorney's letter had arrived 11 weeks after the acceptance email, with no specific itemization, referencing only material deficiencies in the abstract. He had signed a contract that made his entire position legally untenable. And he had apparently never read past the payment schedule. That evening, I sent my attorney a revised instruction. I was not settling, I was filing. My attorney filed a civil action in the relevant county court. The claim was straightforward: breach of contract for non-payment of a properly invoiced amount of $19,000, plus late payment penalties accrued under the specific terms of Clause 14, plus attorney's fees as provided under the fee-shifting clause, in the same contract, a clause I had not fully noticed until I read the contract through for the second time. The fee-shifting clause stated that in any dispute arising from non-payment where the agency prevailed, the client would be responsible for a reasonable contribution to the agency's legal costs. Gareth's attorney filed a response within 2 weeks. The response reiterated the deficiency claims. It named no specific deficiency. It referenced no specific deliverable. It used the same abstract language as the original letter. My attorney responded with one document. 47 pages. Every sign-off in the project, every phase approval, every revision confirmation, the final acceptance email with its full header and timestamp, and a timestamped archive of 6 weeks of commercial deployment screenshots, ad campaign metadata. A live site capture, all dated after the acceptance email, and all predating the attorney's letter by weeks. And then came the part I did not expect. Gareth's attorney did not respond for 11 days. When the response arrived, it was not a counterfiling. It was a settlement offer. The full $19,000 plus 50% of the accrued late payment penalties. My attorney called me within the hour. She said that in her experience, opposing counsel for a corporate client does not offer settlement terms that include penalties, not 60% of them, not any percentage of them, unless they have reviewed the underlying contract and concluded that the client's exposure at trial is materially larger than the settlement figure. She was right about the exposure. The fee-shifting clause meant that a trial judgment in my favor would include a court-ordered legal fee contribution on top of the principal amount. The intellectual property clause meant that 6 weeks of commercial deployment of assets the client did not legally own created a separate cause of action under copyright statute that my attorney had flagged in her initial filing notes and that Gareth's attorney had clearly identified as an additional vulnerability. We countered. My attorney was specific and calm. We asked for the full $19,100% of the accrued late payment penalties and a legal fee contribution representing 60% of my documented attorney costs. When Gareth's attorney called my attorney to discuss the counter, he said something during that call that my attorney relayed to me word for word. He said, "Your client built an unusually thorough contract." That sentence meant more to me than the settlement figure. The matter resolved 14 weeks after I filed. A wire transfer arrived for the full negotiated amount, the principal, the full penalty accrual, and a legal fee contribution that covered approximately 60% of my total attorney cost. There was no trial. There was no confrontation. There was no meeting where anyone raised their voice. There was a signed contract, a 47-page documentation file, and a clause that had been sitting in my service agreement for 3 years, waiting for exactly the situation Gareth believed he could walk away from. After it resolved, I looked up the vendor forum posts again. I found contact information for Diane and Marcus. I reached out to both of them, not to share the outcome, but to share the clause language. Marcus responded the same day. Justice did not undo the 4 days I spent sitting in my car outside that coffee shop, unable to go back inside my own business. It did not give back the weeks I spent building the documentation file while also running a team, managing current clients, and pretending to everyone around me that the quarter was going normally. What Justice did was close the door on the next vendor. Gareth's attorney now has in his file a client with a documented pattern of this behavior, a civil judgment, and a level of contractual exposure that changed the calculation the next time this situation arose. The next vendor he tried this on would face a different version of Gareth than the one who had sent that 6:14 in the morning email. That is what a well-written contract does. It does not prevent the dispute. It determines who is standing at the end of it. I was not the first person Gareth had done this to. I was the first one who had built the folder, all of it, before the fight began. What you build before anything goes wrong is the only thing that matters when everything does. Marcus's email came in on a Tuesday. He had been building his new agency for 8 months. He had a prospective client, a regional marketing group, looking for a full rebrand package. He wanted to know if my contract language was something he could adapt for his own agreements. I sent him the full template. We scheduled a call for the following week. He had done solid work on his intake process, tighter than mine had been when I first started. At the end of the call, he mentioned the prospective client by name, the regional marketing group. And when I looked up that company, the registered name, the address, the marketing director listed on the company website, I recognized the structure. If you have seen this pattern in your own business, leave it in the comments below. You may already be one piece of someone else's folder.